Good afternoon, everyone. Today we will discuss a very important case that is provided in the your case material of the company law, Cotman versus Borougham. And this case we read on the doctrine of the ultravirus. So to understand this case, first we need to understand that what is the doctrine of ultravirus very briefly, and then we will discuss this case. See, the doctrine of ultravirus is the concept where any act done by the company or the director on behalf of the company, both are same thing, will not bind the company because it is outside the object clause of the company for which company is formed. You remember that under section 4 of the Companies Act 2013 that talk about the memorandum, subsection 1 clause is talk about that the object clause has to be defined, but there is no guideline that what actually one has to write for the object. And one thing we infer from the section 3 of the Companies Act, section 3 says that a company may be formed for lawful purposes. That means the object can be or object must be lawful only. But how many objects can be there in the object clause? The company law is silent, and there may be more than one objects for that. Okay. Then the next thing is that if an act is done, whether that act would be ultravirus or intravirus, we have to see that whether that disputed act can come under any clause of the object clause or any act that is auxiliary or naturally corollary to the main object clause, then that would also be intravirus. Other than that act would be ultravirus. The same thing like we discuss under the constitutional law class, that the government can make or the government can do only those activity that are allowed by the constitution. So here the company can do only those act that it is allowed either by the Companies Act or by the object clause or anything that is subsidiary or auxiliary to the object clause. Now on that, there is sometimes student ask that what is the consequence if an act is done by the company and that act is outside the object clause, who will be responsible? See, as I said, that company would not be responsible. That means suppose I am person A and I made a contract with company X, and that contract was outside the authority of the company X. So now this contract I cannot enforce it. Suppose I have supplied the goods to the company X. I cannot ask the money from the company X because the company X will have this uh, ground that it is ultravirus act, it is not beyond its authority, and so the ultravirus act will not bind the company. Okay. And so there is, it seems to be that it is injustice for the third party that is dealing with the company, and for that the justification or reasonable protection is that object clause is the part of the memorandum, and memorandum, if you remember, we have to supply to the registrar when we go for the registration of the company under section 7. Whenever there is any change in the memorandum, change in the object clause also, for the alteration of the memorandum section 13, then also the register we have to tell to the registrar, inform to the registrar, and registrar will make the changes in the register. And so the registrar office have the knowledge of the object clause, and it is constructive notice that this is the public document and any person can go and watch it. So before dealing with a company, one should also see the object clause of the company to see that whether the contract that one person is going to form with the company, whether that contract or whether that act is within the authority of the company or not. The next thing is, then who will be responsible? If company will not be responsible, who will be responsible? See, the directors act as an agent. Okay, and so basically, who mislead this third persons to deal with the company? These directors. It is the duty of the director to know that what is the object clause, what the company can legally do, what the company can legally bind, and so they will be personally liable for it. So that is the about the liability. Now the first case before the Cotman versus Borougham we discussed was Asbury Railway Carriage and Iron Company versus Rich, and there in that case we read that Lord Chancellor Carrion said that maybe in object clause there are more than one objects for which the company was formed, and different words are used, but all those different words or clauses will not be interpreted as an independent object clause. There has to be one main object, and accordingly other clauses also has to be interpreted. So the main object clause rule has been propounded by the House of Lords in the Asbury Railway Carriage and Iron Company Limited versus Reach. Now this case that we are supposed to discuss now, Cotman versus Borougham, 1918 to 1919, All England Reporter 265, House of Lords. 1918-1919 means this is the joint the publication of the All England Reporter of both year 1918 and 1919, and on that publication on the page number 265 you can find this judgment. Okay, now there is the facts of this case. If we see the facts of this case, the facts of this case are very simple, that there was a company and the name of that company was Escubo Rubber and Tobacco Estate Limited. This was a company registered on the April 6, 1910, and this company has the object clause like all other company, but they have learnt from the earlier case Asbury Railway Carriage and Iron Company Limited, and so the business community are very clever, so they have drafted the object clause in such a manner that to supersede the main object rule propounded by the Lord Chancellor Carrion in the Asbury Railway Carriage Company. First of all, in the object clause there were 30 clauses, the different objects they have specified, and then to overcome with the judgment of the Asbury Railway Carriage and Iron Company, they have put a declaration that was on the 30th clause, that the object set forth in any subclause of this clause shall not, except when the context expressly required, be in any way limited or restricted by reference or inference from the term of any other subclause or by the name of the company. None of such subclauses or the object therein specified or the power thereby conferred shall be deemed to subsidiary or auxiliary merely to the object mentioned in the first subclause of this clause, but the company shall have the power to exercise all or any of the power confirmed by any part of this clause in any part of the world. And so this declaration that is present in the 30th clause of the object clause is to nullify the effect of the Asbury Railway Carriage and Iron Company Limited versus Rich. The promoters know that maybe at any point of time when there is the dispute with respect to the act of the company, that whether that act the company will bound by that or not. That means for application of doctrine of ultravirus. And then the House of Lord judgment, that forming the part of the law where law was propounded, that the main object rule, that may be different clauses, but these different clauses will not be independent. They have to read in light of the main object clause. And so in this declaration, they want to nullify the effect of the earlier judgment of the House of Lords. Now, the object in the object clause, there is clause 8 and 12. Clause 8 and 12, if we read, is talking about that what the company can do, and that is relevant for our act. Clause 8, subclause 8 is talking about to promote, form, issue and be interested in any company or companies either in Great Britain, Guyana or elsewhere, and to take, acquire, hold, transfer, sell, surrender or otherwise dispose of and deal in the share, stocks, bond, obligation. And clause 12, to buy or otherwise acquire in any way, hold, sell or deal or with or in any stock, share, securities or obligation of the government, authority, corporation, etc. Okay, so these three subclauses in the object clause we have learnt. Now what was the disputed act? See, the company, then what it did, that the company has acquired the share in an oil company. Okay, and some shares this company has acquired in the Anglo-Cuban company, that oil company, and for that the money has to be paid. I'm cutting short some facts. Now we have to apply that whether making the contract of underwriting the share or the contract of getting the share in another company, oil company, is whether ultravirus or intravirus. See, whenever there is the questions on the doctrine of the ultravirus, or whenever someone asks, or if before you there is this problem of applying the doctrine of ultravirus, two things has to be kept in mind. The first is we have to see the object clause in totality. We have to read it. Then we have to see the disputed act on which there is a question that whether this is ultravirus or not. And then we have to find out that whether this activity can be fall under any of the subclauses of the object clause, or is it necessary as a fairly auxiliary to that. Okay, if it is within the object clause or if it is necessary for the auxiliary work, then it would be intravirus, otherwise it would be ultravirus. Here in this judgment that is given, Cotman versus Borougham, in our case material, the judgment is of the three judges, and both these three judges have written the different judgments. These three judgments are available in your case material. The first is Lord Finlay, then Lord Parker and Lord Ranbury. Lord Finlay and Lord Parker, both judgments are very interesting and lucid and clear manner, and I recommend that one has to read these two judgments at least. Lord Parker and Lord Finlay both approaches with different concepts, but they have ultimately reached at the one conclusion. First to the Lord Parker. Before the Lord Parker, it was argued that whether a particular act is ultravirus or not, we have to see that if the company would not have any work to do but only to that act that is in the dispute, in that case can we see that the company lose its substratum and it can be ordered for wound up. Earlier also I have said that if the different object that is specified in the object clause, if it is not possible for the company to carry on the business because those objects cannot be achieved for those objects, like if the company is for manufacturing of electronic items, or maybe electrical goods, and these things are not possible for the company to do. So in that case, what would be the consequence? Because if the company would do other than these act, then it would be ultra virus, and doing these act if not possible for sake of simplicity. So in that case, what would be the consequence? And that I said that for that, in the German coffee date company case also, it was held that when the company cannot cannot carry on the business to do whatever written in the object clause, then it would be considered that it lose its substratum and it can be wound up. So this argument was made by the liquidator in this particular case, and Lord Parker said that no, I am not impressed by this argument, because the loss of the substratum and in consequence for winding up of the company is the question of equity between the shareholders and the company. In that case, the equity comes in ground, the fairness comes in the ground, that the shareholder who have invested money in the company for doing the business for whatever written in the object, and if that is not possible, the object cannot be achieved, if the company cannot do the business that is mentioned in the object clause, then it is better to wound up the company. And that is the question of the equity, the fairness. But the question of the doctrine of ultravirus is the question between the company and the third person, and that is the question of the law. So the question of the law, that what act the company can be have the liability, and for what act company will not have the liability. And here the Lord Parker said that a particular act, one has to see that whether that act by any interpretation can be seen as within the object clause or not. And for that we have to see the object clause. Then after seeing the object clause, clause number 8, clause number 12 that we have read, that clearly give the power even to purchase the shares, etc., and that clause number 30, that is in the form of the declaration that every clause will be in itself is the independent, would not be auxiliary, would not be read in light of the main clause rule or in the name of the company, etc. Lord Parker said that whatever written in that declaration in the clause 30 is the correct. We have to take the literal interpretation. Whatever written in the object clause, accordingly we have to find out the conduct of the company. When the object clause is the clear, and when the object clause have no ambiguity, in that case we have to rely only and only on the object clause, and here the object clause is relied. Moreover, the declaration in the clause 30 that saying about that all clause are independent, will not take even the help of the name, as per the Lord Parker, that is correct also, because name are can be changed also. And so he was satisfied with the earlier two forum, the judgment of that, and so the appeal was dismissed, and he held that the act is intravirus, it is not an ultravirus. And so from here the rule of the literal interpretation has been emerged out, and the earlier rule held by the House of the Lord of the main object clause was superseded. In the later judgment we will discuss further revisal of the earlier rule in different form also. Then the second judgment of the Lord Finlay. Lord Finlay has argued, and he said that yes, it seems to be that the business community or the promoter have very clearly drafted just to supersede the judgment or the finding or the law propounded in the Asbury Railway Carriage and Iron Company Limited versus Rich by Lord Chancellor Carrion. That is the main object rule. And they have drafted this subclause 30 in the form of declaration that every clause would be independent. But this is not the time that when we see that whether the object clause is proper or not. At this moment of the time, we are helpless and we have to see the disputed act only according to the object that is defined. But yes, Lord Finlay has lamented that this is not the proper way of forming the object clause. First, the object clause is so broad, having the 30 clauses, and it has the possibility to include every business possible on this earth. So what is the very purpose of the object clause? Because the very purpose of the object clause is to define specifically the business of the company to which the proposed company want to do. And so this is the breach of the, you can say, the well settled principle of the law. But this was the duty of the registrar, that not to allow such companies to get registered this type of the object clause. But at that moment when the company has already been registered, we have no opportunity to discuss that whether the object clause is not perfectly valid or valid. And when we are not in the position and we say that yes, at this moment we have to consider it that the object clause is good, in that case the clause 8 and clause 12 both are allowing this activity, and we are even helpless to apply the Asbury Railway Carriage Company to say that these are the auxiliary clause, we have to interpret it in light of the main clause, because that is also not allowed by virtue of the clause 30. And so there is only possibility left is the literal interpretation. And Lord Finlay also said that I also agree with the both the court below him, that it is impossible to say in light of this that the power or the acquisition of the shares in another company is ultra-virus. And so finally with the Cotman versus Borougham, the new principle or the new rule was propounded by the House of Lords, that when there is an object clause and the object clause is clear and lucid, then the only possibility is that court has to interpret whatever written in the object clause. But yes, it is the duty of the registrar before registering to not to get registered those object clause that are not clear. And from that we also learn that whatever the purpose of the object clause is to specify the activities of the company in which the company can do business. And so it is advisable that all the sub clauses in the object clause must be clear, giving the impression that what the company will do. And also there is the limit on the object clause. It would not be in a nature that it would make possible for the company to do all the acts, because that is very, very prejudicial to the shareholder. So with this judgment, Cotman versus Borougham, the new rule has been propounded. In the next video we will discuss the new case, and in that new case the new rule we will discuss on the doctrine of ultravirus. Bye bye guys, enjoy your day.